Order this hearing of the Judiciary Committee's Subcommittee on Federal Courts, Oversight Agency Action, and Federal Rights. We'll proceed with opening remarks from myself, from Ranking Member Kennedy, and we have the good fortune that the chairman of the full committee, Senator Dick Durbin, is with us, and he will offer opening remarks after Senator Kennedy. We'll then proceed to the comments that you have prepared, Judge Wolf, and your full statement and exhibits attached to it will be made a part of the record, so you don't need to concern yourself with that. And then we'll have question and answers with the committee members. So let me welcome you and get underway. 1 month ago, Congressman Hank Johnson and I wrote to the Judicial Conference of the United States asking it to look at recent reports that Justice Clarence Thomas violated the Ethics in Government Act by failing to disclose gifts of travel and luxury vacations provided by a right-wing billionaire. The Judicial Conference's responsibilities under that law are quite clear. If there is, and I quote, reasonable cause to believe, close quote, that Justice Thomas willfully failed to file, then it must refer him to the Justice Department for further investigation. The Judicial Conference is a statutory body, and the Ethics in Government Act is a federal statute. So this is all very much Congress's business. The Judicial Conference has a committee on financial disclosure. Our request about the recent Thomas allegations was sent there. I've urged that committee to act with dispatch and to provide us information to understand how the process is handled. This is not a first. Believe it or not, we've been in nearly this exact situation before. Back in 2011, the nonprofit group Common Cause uncovered that Justice Thomas hadn't reported years of his wife's income paid by a right-wing dark money group. The New York Times reported that Justice Thomas also had not disclosed gifts of free private jet and yacht travel from the same right-wing billionaire. The same kinds of undisclosed gifts from the same right-wing billionaire that were revealed last month. Then, as now, the Ethics in Government Act required Justice Thomas to report these things. And then, as now, the question was whether there was reasonable cause to believe that Justice Thomas's omissions were willful, in which case, then, as now, referral to the Attorney General is required by law. So, the Judicial Conference actions then are the prequel to what is in front of it now. More than a decade later, we're just now getting answers to important questions. Over the past few weeks, I've asked the Judicial Conference who was on that committee, what was its process and rationale, what kind of evidence did it consider, and what were the rules and procedures under which all of this took place. The Judicial Conference's recent response, and I will enter the Judicial Conference's response and the 3 letters of mine to which it was responsive into the record, is a helpful start, but there is more that we need to know about those events. We'll hear today from someone who can help us with pertinent insight into what the Judicial Conference and its Committee on Financial Disclosure did back in 2011. Judge Mark Wolf was a member of the Judicial Conference in 2011 and 2012. And his experience on the Judicial Conference provides special insight into its normal operations and how the conference handled the incidents involving Justice Thomas. Congress has a role in making sure that our courts are administering federal ethics laws fairly and as intended. If they aren't, we need a robust record of what has gone wrong and what new laws might be needed to fix it. Judge Wolf's testimony will help us build that thoughtful record, and we are grateful to him for appearing today. Senator Kennedy, then Senator Durbin.
Thank you, Mr. Chairman. The assault comes in waves. The current assault on the United States Supreme Court as an institution started on May 4th, 2020. I remember it like it was yesterday. started on the steps of the United States Supreme Court. The Democratic leader of the United States Senate said, and I quote, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind," the Democratic leader of the United States Senate said, "and you will pay the price. You won't know what hit you if you go forward with these awful decisions." Now, we're supposedly here today to hear the latest chapter in the fairy tale of Supreme Court corruption. As I implied, this is a continued effort to undermine a United States Supreme Court that isn't ruling the way that some of my Democratic colleagues want. How do we know today's outrage is unjustified? Well, at least 4 of my Democratic colleagues, and I suspect many Republicans on this committee, have done exactly what Justice Thomas did: amend their financial disclosures. I'm willing to stipulate that, like Justice Thomas, my colleagues have done nothing wrong intentionally. Amendments are pretty commonplace. According to the Judicial Conference, about which we will probably hear a lot today from this witness, Justice Thomas, in 2011, immediately amended his financial disclosures to include his wife's employers for a number of years. That's it. That's all, folks. That's what this is all about. Of course, everybody knew at the time that Mrs. Thomas worked in politics. And everybody knew at the time that Mrs. Thomas works in policy. So it's pretty unclear what the bombshell is here. Maybe because there isn't one. Justice Thomas either misunderstood or misinterpreted, I don't know, the disclosure obligations. And so in 2011, he filed an amendment, which the law calls for, to tell us what we already knew. The Judicial Conference has a committee on financial disclosure. The Judicial Conference's Committee on Financial Disclosure cleared Justice Thomas. Did I mention? They cleared him. They found no evidence, none, zero, nada, zilch. They found no evidence that he acted willfully or improperly. And as the Judicial Conference told our chairman just 2 days ago, the conference's Committee on Financial Disclosure cleared Justice Thomas not once, not twice, not 3 times, but 4 times at 4 separate points under the leadership of 2 different judges who served as chairman of that committee. Now that ought to be the end of the story. But it turns out that for the last dozen years, a lone federal judge who is with us today has been obsessed with complaining that the Judicial Conference got it wrong. Obsessed. Perhaps he thinks they are crooks too. A few data points on our witness today, Judge Wolf. Number one, as a sitting federal judge, he wrote in 2021 for NBC News in support of H.R. 1. This was the partisan Democratic bill to federalize elections, to remove them from state and local government. Are federal judges supposed to advocate for policy changes to current law? No. But Judge Wolf did. Number two, the Associated Press has reported that, quote, I'm going to quote now. These are AP's words, not mine. A longtime FBI informant believed that Wolf had leaked information to the mob when he worked for the U.S. Attorney's Office, end quote. Then, as a judge, he refused to recuse himself in a case involving the mob. Number three, a few years later, federal prosecutors accused Judge Wolf of entertaining a defense witness in a murder trial. Are you kidding me? A highly unethical move, that's an understatement, at Martha's Vineyard, which led to his recusal to avoid the potential for appearing biased after he'd been 15 years into the case. Talk about an inefficient use of scarce judicial resources. Now, this is the Judge Wolf whom we're going to hear from today. A self-described nonpartisan interested in fair judicial administration. The proceedings of the Judicial Conference are highly confidential. The proceedings of its Financial Disclosure Committee are confidential too. Multiple advisory opinions and even the Judicial Code of Conduct say that a sitting judge should only testify before a partisan body if they are an expert. And yet Judge Wolf is going to tell us all about them, even though he didn't even sit on the committee that investigated Justice Thomas. As the Judicial Conference emphasized, professional, non-political career staff of the Judicial Conference's Financial Disclosure Committee viewed Justice Thomas's amended disclosure and called it what it was: routine. But the judgment from nonpartisan staff and from the committee's Democrat, not Republican, but Democrat appointed head didn't satisfy Judge Wolf. He continued on. And he eventually tried to force a vote at the Judiciary Conference. Obsessed. Why? For the same reason that some Democrats keep holding public smear campaigns like this one. Judge Wolf wasn't getting his way from the head of the Judicial Conference or from Chief Justice Roberts himself. Ethics experts and fellow judges agreed that there was no there. But maybe the press could be convinced that even when there's no smoke, there's fire. We've never seen that happen in Washington. Apparently, someone convinced the press to swallow Judge Wolf's line. As of 2 weeks ago, you can read the play-by-play of how Judge Wolf repeatedly and unsuccessfully pressed the Judicial Conference to bend to his will in a Bloomberg article written more than a decade after the fact. By the way, the Judicial Conference says that, quote, judges should not discuss pending or impending cases, confidential information, or controversial matters with the media. The media revelation is interesting, not because it demonstrates any wrongdoing on the part of either Justice Thomas or Chief Justice Roberts. None. But because it implies wrongdoing on the part of its possible source. Possible source. The information leaked to this reporter is highly confidential. And if it was leaked by a sitting judge, it was unethical. In other words, this hearing, we're here to focus on potential ethical lapse. Could it be that this hearing is only possible because of a clear ethical lapse? I wish some of my Democratic friends, and they are my friends, and Judge Wolf were as concerned about this leak as they are about routine and proper disclosure amendments. And by the way, anyone who wonders why appropriate confidentiality can be so crucial to our legal system and to the safety of the men and women on the bench can give Justice Kavanaugh a call. Just ring him up. Leaking confidential information to affect an outcome or get your way is always wrong. And sometimes it's dangerous. So why does the nauseously woke left to continue to employ these tactics? That's a fair question. We got the answer. In New York Magazine told us 2 days after the Bloomberg piece on Judge Wolf's advocacy was published. I want to read to you the magazine's advice. Quote, "It is therefore in the interest of the progressive movement to undermine the court's legitimacy. It makes sense for progressives to publicize Thomas's obscene indulgences. But I think it's true that the end goal of doing so isn't to secure ethics reforms that will render the Supreme Court less vulnerable to perceptions of corruption. The point is, or at least it should be, to promote the perception of judicial corruption." End quote. If you can't control it, you burn it down. Like others, Judge Wolf's goal seems, to me, to be political. This hearing has been entirely structured around him. Entirely. Who has, as a supposedly nonpartisan federal judge, endorsed partisan legislation has been the catalyst and the only witness for a partisan hearing. Is Judge Wolf planning on launching a super PAC next? So let me sum it up. More than 10 years ago, Justice Thomas amended his financial disclosures to include facts that everyone already knew, which he had inadvertently, I shouldn't say inadvertently, I don't know, omitted. People file amendments all the time. Both Democrats and Republicans on this committee have repeatedly done the same thing. I don't hold that against them. and neither should anyone here. This routine amendment resulted in a bureaucratic knife fight that Judge Wolf instigated against a Supreme Court justice and the Judicial Conference. He lost resoundingly 4 times. Did I mention that? He lost 4 times. And here he is a dozen years later to tell us all about it. Even when the facts vindicate the accused, the nauseously woke left can't help but sling mud, especially when it comes to the Supreme Court. If we can't control it, let's burn it down. Forget innocent until proven guilty. The loon wing of the left insists that good justices are guilty even after they've been found innocent 4 times. And that's the perpetual political carousel that brings us here today. It makes me want to gag.
I thank the ranking member for his colorful remarks and turn to Chairman Durbin.
Thank you, Mr. Chairman, and thank you to Senator Kennedy for holding this important hearing today. I want to thank Judge Wolf for his willingness to testify about the role the Judicial Conference Committee on Financial Disclosure plays or fails to play when it comes to overseeing Supreme Court justices' compliance with the Ethics in Government Act. I'd like to start by saying that Senator Kennedy, my friend, has identified May 4th, 2020, as the kickoff date for this so-called political exercise. I would like to show to my colleague and put in the record a copy of the letter which I sent, signed by Senator Leahy, Senator Whitehouse, and others, to Chief Justice John Roberts, dated February 13th, 2012. February 13th, 2012, 8 years before this date in 2020. And what were we asking or making inquiry on? We were asking about information on the Code of Ethics and the Code of Conduct and the ethical behavior of the Supreme Court justices, in particular one whose situation had come to light, who had been receiving some gifts of some sort, and his wife had been receiving some income which was not properly reported. So to say this all started in May 4th, 2020 is just plain wrong. I've got the letter here to prove it, and I ask consent to enter it into the record. Let me go further and say that for more than a decade since sending this letter and before, I've been calling on Supreme Court justices to be held to at a minimum, to the same ethical standards as every other federal judge. That's the outrage that precipitated the comments by the ranking member. The notion that the Supreme Court justices, all 9 of them, would be held to the same ethical standards. As I mentioned, I started that in February 2012. I want to commend the chairman, Senator Whitehouse, who has really done yeoman's duty in pursuing this issue long before the current publication by ProPublica of information that brings us here today. I thank him for his leadership in that, and I think he's appropriately chairing this subcommittee on the courts at a moment in history when he's needed now more than ever. I again urge Chief Justice Roberts, after the recent ProPublica revelations about luxury vacations and travel given to the Supreme Court Justice by billionaire Harlan Crow, I invited the Chief Justice on behalf of the committee, Democrats in the committee, to testify on this issue. He declined. I'm sorry that he did. I then called on him to rescue the reputation of the court by simply taking action to respond to this well-documented outrage. For anyone, including my colleagues in the Senate on both sides of the aisle, to believe that this is normal, acceptable conduct for an elected official, Supreme Court Justice, Senator, to be receiving hundreds of thousands of dollars worth of gifts and vacations, to have your mother's home purchased by an individual so she doesn't have to pay a mortgage any longer. The list just goes on and keeps moving on. And the American people don't understand this. As Judge Wolf, I read your statement this morning, and I'm not going to quote it because it may be some elements that you want to quote yourself in your opening statement. But what this court has to rely on is a confidence of the American people in the integrity of justices when they hand down decisions. If they hand down controversial decisions and the American people don't like them, they can at least say, well, that's the court. They go their own way. But if there is any question about the integrity and character of these justices, it really undermines the institution of the court. That's why I appealed directly to Chief Justice Roberts. This is the Roberts Court. This is his court in history. And what he chooses to do by way of ethics is going to be remembered for generations. I believe he can, and I hope he will step up, raise his hand, and say that's the end of the special treatment for Supreme Court justices. They will be held to the same ethical standards as every other federal judge. That's not too much to ask. It's the very least we should ask. I thank you, Judge Wolf, for being here today. I read your testimony in its entirety this morning. I'm looking forward to ask you a few questions after you've had an opening statement. Thank you, Mr. Chairman.
Thank you. I will now introduce our witness, but before I do, let me say that Judge Wolf, the personal character of the various assertions and insinuations that the ranking member has made, I think entitles you to an opportunity to respond. The proper way to do that, I think, rather than deflect the course of this hearing, is to allow you to respond as if those were questions for the record, so that after the hearing is concluded, you will have a week to offer such response as you feel is appropriate, or none if you feel that is appropriate. But I would prefer not to have the course of the hearing, which is an inquiry into the procedures and processes of the Judicial Conference, deflected by those assertions and insinuations. Judge Wolf is a senior United States District Court judge for the District of Massachusetts. Judge Wolf was appointed to the federal bench in 1985 by President Ronald Reagan. And from 2006 to 2012, Judge Wolf served as the chief judge for the District of Massachusetts. From 2010 to 2012, Judge Wolf was a member of the Judicial Conference of the United States, where he chaired the Committee on District Judges and was a member of the Judicial Conference's committees on codes of conduct, criminal law, and rules of criminal procedure. Before his appointment, Judge Wolf was a deputy U.S. attorney and chief of the Public Corruption Unit in the District of Massachusetts. He also served as special assistant to Deputy Attorney General Lawrence Silberman and as a special assistant to Attorney General Edward Levi. Judge Wolf, you're recognized for your opening statement. As I said before, your complete testimony and exhibits will be made a matter of record.
Senator, thank you. I have, as requested, prepared a little less than 10 minutes of remarks. And I know I'm not in my courtroom, so I don't set the procedures. I'm very sorry that Senator Kennedy has left, but I hope that I can today, in whatever time might have been ceded to him if he remained, address some of the inaccurate statements he made, rather than doing that exclusively in writing, if time permits. But I do thank you for requesting my testimony about how the Judicial Conference of the United States in the past discharged its responsibility under the 1978 Ethics in Government Act that applies to all federal judges, including Supreme Court justices. I am testifying as an individual, not as a representative of the Judicial Conference or the federal judiciary. I would like to highlight some of my lengthy written testimony in a further effort to be helpful to you and to the Judicial Conference. The Act codifies the belief that sunlight is the best of disinfectants. Transparency of financial information of a justice or a judge in his immediate family encourages justices and judges to decide cases impartially, as we are sworn to do, and encourages reasonable people to believe that we are doing so. The Act creates criminal and civil penalties for willfully falsifying information or willfully failing to file required information. In addition, 18 United States Code Section 1001 makes it a crime punishable by up to 5 years imprisonment to willfully falsify or conceal information. The Act defines a specific and limited role for the conference. It provides that the Judicial Conference shall refer to the Attorney General the name of any individual it has reasonable cause to believe has willfully failed to file a report or has willfully falsified or willfully failed to file required information. Reasonable cause is analogous to probable cause. It's more than bare suspicion, but less than by a preponderance of the evidence. It is not the conference's duty under the Act to determine whether a justice or judge has violated the statute. The conference is to decide whether there is reasonable cause to believe a willful violation occurred. If reasonable cause exists, the conference must refer the justice or judge involved to the Attorney General. This division of responsibilities is wise and important. I was a conference member in 2011 and 2012. Thus, I shared responsibility for assuring the Act was properly implemented and enforced. In 2011, the conference received 5 letters, and the Supreme Court received 1, in part alleging that from 2003 to 2009, Justice Clarence Thomas did not make the required disclosure that the Heritage Foundation employed his wife. I believe for many years he checked that her employment was none. The justice evidently knew of the requirement because he had previously disclosed his wife's employment, including in his early years as a justice. Although the Act does not require disclosure of the amount of compensation, the letters stated her compensation was substantial. The first letter was sent in January 2011 and was referred to the conference's Committee on Financial Disclosure. Justice Thomas promptly amended his reports, stating that he misunderstood the Act's requirements and that the errors were inadvertent. Nevertheless, the conference still had a duty to decide if there was reasonable cause to believe his omissions were willful, and if so, refer him to the Attorney General. Policy of the conference required that committees' reports to the conference include all their activities since the last biannual conference meeting. This information ensured that each conference member had the knowledge and ability to require discussion and possible decision by the full conference. However, the Financial Disclosure Committee's reports for the March and September 2011 conference meetings did not reference the issues concerning Justice Thomas or any related committee activity. The rest of the letters to the conference amplified earlier allegations, questioned whether Justice Thomas's omissions actually were inadvertent, and raised other concerns, including allegations that Justice Thomas had failed to report travel on Harlan Crow's jet and yacht. Those letters were sent on or after the date of the September 13, 2011 conference meeting. In early 2012, I found some of the 2011 letters on the internet. I told Judge Thomas Hogan, Secretary of the Conference, that I was concerned that other conference members and I had not been informed of the letters in their request to refer Justice Thomas to the Attorney General. I suggested that the matter be discussed at the March 2012 meeting. He told me that he had referred the letters to the Financial Disclosure Committee and asked me to wait until the committee chair, Judge Joseph McKinley, responded to him. Judge Hogan subsequently gave me Judge McKinley's February 23, 2012 response. I spoke with Judge McKinley and became concerned that in 2011, the committee may have done nothing after Justice Thomas amended his reports and had not addressed the question of whether reasonable cause existed. Judge McKinley told me that the staff had not referenced the letters in the last 3 reports to the committee because they regarded them as routine. He also said, however, that this was the only time members of Congress or the public had ever requested a referral to the Attorney General. There was also no reference to the letters in the committee's report for the September 2012 conference meeting. Judge Hogan told me he had received an April 17, 2012 2012 revised version of Judge McKinley's February response, and he wrote to the letter's authors on April 30th to inform them that the committee had decided against referral. I asked Judge David Santel, chair of the conference executive committee, to put the matters concerning Justice Thomas on the September 12 conference agenda. The executive committee denied my request. I then exercised my right to move the committee report to the discussion calendar. I told Judge Hogan that I would send a memorandum to conference members before the meeting explaining my concerns. He urged me not to include the 2 letters from Judge McKinley describing the committee's actions. I acquiesced and did not attach them to my memorandum. At the September 11, 2012 meeting, I moved to disapprove the committee's report and require revision of the prior 3 reports. Chief Justice Roberts allowed me to speak briefly about the deficient process and whether the conference was properly performing its important but limited role of determining whether reasonable cause to refer to the Attorney General existed. I hoped to generate discussion. When I concluded, the Chief Justice immediately recognized Judge Santel. Judge Santel successfully moved that the issues be returned to the committee for a report at a future meeting in which he knew I would not be present because my term as a conference member was ending. It is unfortunately relevant to consider these events now. The Act only serves its vital purpose if the conference understands and properly performs its role. I believe that in 2011 and 2012, it did not. First, despite Congress and the public raising serious allegations and the conference referring them to the committee, it appears that the committee did little to nothing for at least a year. The committee should have, at the very least, addressed the allegations at the March 2012 committee meeting. Second, the committee's process was opaque. In 2011, likely through inaction, then in 2012, by insistence, the committee did not disclose to members of the conference the allegations, the actions, if any, it took, and the reasons for any decisions. Third, the statutory mandate for the conference, and by delegation to the committee, was to determine whether there was reasonable cause to refer, not the ultimate merits of whether the justice's violations were willful. However, in conversations, letters, and reports, the committee repeatedly framed its inquiry using the wrong standard. As I frequently tell my law clerks, if you address the wrong question, you are likely to get the wrong answer. Thank you.
Thank you very much, Your Honor. It sounds to me like the nutshell version of your testimony is that the wrong question was answered, i.e. willfulness rather than reasonable cause. It was answered in the wrong venue, to wit, a committee or subcommittee or perhaps individual determination instead of the judicial conference, as the statute suggests, with the result that the deliberations were, to use your words, opaque. They took place out of public view. Is that a fairly accurate summary?
Yes, with the caveat that it appears to me, having revisited this and having more information in some respects than I had in 2012, it appears to me that no decisions and possibly no action was taken in 2011. And that's another concerning matter.
The one place where there is an opportunity for public awareness of what is happening in this process is at the judicial conference, correct?
Well, that's not completely correct either, because I have scoured the Guide to Judicial Policy, which is not a public document, and the judiciary's description of the judicial conference and its committees. There is nothing in there that says that a judge or justice can't talk about what transpired. However,
I'm asking a bit of a different.
well, I know, but however, I expect that some of you at least have attended those meetings. The public is not allowed to observe, to see the proceedings. They're allowed to see this hearing. They can judge my credibility if they're interested in my motives. But that kind of transparency doesn't exist in the Judicial Conference. And there are certainly things that should properly be discussed confidentially and maintained as confidential, particularly before decisions are made, the essence of the deliberative process privilege, pre-decisional. But striking the right balance between transparency and accountability is, I think, for the Judicial Conference, like every branch of government, important.
The one thing that is made public is the report of each judicial conference after the meeting, correct?
A report of the proceedings.
Yes.
Which is a summary.
And the report of the proceedings would tend to include reports to the conference from its committees. So the one way that any of this would become public is only if the determination that was made here was actually referred by the Financial Disclosure Committee to the Judicial Conference, and then that would be reported in the summary of the Judicial Conference's activity, correct?
Yes.
And that did not happen in this case.
The reports of the Judicial Conference, the reports of the Financial Disclosure Committee were under Judicial Conference policy required to include everything that the committee had discussed and decided since the last conference meeting, even if no recommendation for conference action was being made. The 4 reports starting in March 2011 of the Financial Disclosure Committee to the conference it contained no reference, no hint that any letters had been sent or any issues have been raised.
So the only disclosure that the Judicial Conference provides any record of in these matters is the April 30 letters from the Judicial Conference that summarily say nothing has been presented to support a determination that Justice Thomas's failure to report the source of his spouse's income was willful, or that Justice Thomas willfully or improperly failed to disclose information concerning travel reimbursements. That is it that has been public, correct?
As far as I know, yes.
As far as I know, too. I think as the convention is to go to the leading Republican, that Senator Lee is you right now, and then Chairman Durbin.
Mr. Chairman, I'd note at the outset, I'm concerned by the tone and tenor of this hearing. It feels an awful lot like a political witch hunt, which may be in the process of being aided and abetted by a member of the judiciary. After reading the letters from Senator Whitehouse, responses from the Administrative Office of the Courts, and news articles, this appears certainly like sour grapes, or perhaps some combination of sour grapes and a political witch hunt. We've got people who are trying desperately to make a lot out of something that isn't there. And I'd like to offer into the record, Mr. Chairman, a letter from the Secretary of the Financial Disclosure Committee, indicating that 2 iterations of the committee and 2 subcommittees found that there was no willful violation by Justice Thomas.
May 15th letter?
Yes, this is the May 15th letter. Thank you.
I'm sorry, what letter is that, please?
a letter dated May 15th to me from the Honorable Rosalind R. Mouskopf answering letters that I had sent April 21st, 27th, and May 5th.
Judge Wolf, how was the press, and specifically Bloomberg News, Bloomberg News reporter Zoe Tillman, able to review your August 2012 letter to a group of Judicial Conference colleagues? How did that happen?
I do not know. She sent me an email asking if I would speak to her, and I communicated that I declined.
Doesn't the timing of this seem a little odd? I mean, this is something that occurred 11 years ago, and days before this hearing, it magically appears. Did you leak a copy of the letter
No.
to Ms. Tillman? Did you leak it to anyone else who may have given it to Ms. Tillman?
No, and actually, of course, I've thought about that question too, and you'll excuse me if I say something that may be supportive of all of you. I had not given those letters to any senator, any member of his or her staff. The administrative office would have these records.
Who did you give them to?
Nobody.
No one.
Correct. And Mr. Lee, I worked closely with your father when he was the Assistant Attorney General for the Civil Division, and I was Attorney General Levy's liaison to him. I think your father would have been very disturbed by the matters that I've addressed, A, and B, would have engaged, and I would have thought that members of the Senate from both parties would be concerned about whether the judiciary and anybody else was properly
Seriously?
interpreting it.
You're going to bring up my dad? You're here attacking a member of the United States Supreme Court on grounds that are frivolous, on grounds that have been rejected by two different iterations of the Judicial Committee that you're talking about. Twice rejected, and you have the audacity to come in here and invoke the memory of my late father? It's shame on you, sir. Okay, look, you submit a statement to this committee. It's a lengthy statement. Contains 122 footnotes. On page 2, you state that you're testifying, quote, as an individual and not as a representative of the Judicial Conference of the United States or the federal judiciary, close quote. Did your law clerks help you draft this?
Yes.
Who else helped you draft it? Who else was involved in the drafting of it?
Just my law clerks, although I did consult one of my colleagues about it.
Okay, so you're not here on behalf of the conference, and yet you used judicial resources to do it, and you consulted one of your colleagues to do it, and you're speaking solely in your capacity as someone who served on the committee, and so you're purporting to speak for the committee.
No, I'm not. I said I'm speaking. When I was invited first to be interviewed, I thought by Senator Kennedy, who declined to meet with me, but I did meet with his staff. And then when I was invited to testify, I immediately informed the Administrative Office of United States Courts. I was familiar with the guidance, again, not public. The judges are free to speak. The Canon 4, as you saw when you read my piece, encourages judges to speak on matters relating to the administration of justice when they have experience or expertise. And the only thing that the administrative office said to me was, be sure to point out that you're testifying as an individual, which I had already done in what I was drafting. And if I wanted any ethical guidance, it mentioned who to call.
Okay.
But
Senator
canons,
Durbin?
I'm sorry, are vividly clear, and there wasn't any open issue on which to consult.
Yeah.
Senator
And
Durbin.
Yet you're here speaking in that capacity based on your service on that committee, notwithstanding the fact that your motion to have it considered by the full conference as to your suggestion that Justice Thomas's disclosures were willfully wrong was rejected.
Senator Durbin.
Judge Wolf, I've been surprised, in a way, at the reaction of my Republican counterparts to this issue. Just last year, there was a bipartisan effort by two members of this committee, one Democrat, one Republican, to establish the standard of disclosure when it came to stock ownership by federal judges when they had before them a case that might involve that same stock or company. And it struck me that there was a true bipartisan spirit, that this was a reasonable ethical standard and should be submitted for the judiciary to live by that standard. Yet when we had a hearing about 3 weeks ago on issues related to Justice Clarence Thomas and his disclosure standards, it really broke on party lines, and the same thing has happened today, which comes as a disappointment to me as much as a surprise. This notion that anyone in public office at a level of senator or Supreme Court justice can receive hundreds of thousands of dollars worth of gifts in travel and hospitality and not disclose it and argue that, well, that was inadvertent, is to ignore the obvious. The American public takes a look at that and said, what is this judge doing? How can we trust his judgment if one Texas billionaire has such a large part of his life in terms of his attention? What's your response to that?
Essentially, what I think you've characterized accurately based on what I hear, just being a citizen, may be the reaction of the man in the street. However, as I wrote in my testimony, I think the Ethics in Government Act emerged after the Watergate scandal for good reasons. Greater transparency of financial activities of public officials, not just judges, was understood to be very important to assuring, among other things, the impartiality of judges. And I think that act struck, as it's written, a very appropriate balance. It gives the Judicial Conference the opportunity and the obligation to determine whether there's reasonable cause to believe there's been a willful violation. It doesn't permit them, the Judicial Conference, to make the ultimate determination of whether there was. If the Judicial Conference makes a referral to the Justice Department, it should diminish the potential and the perception that the Justice Department has launched a witch hunt against judge or justice. But the members of the Judicial Conference are not all impartial. There are friendships, there are professional relationships, there are interests.
That goes to the heart of the issue before us, and that is the fact that the Supreme Court of the United States of America has not established code of conduct and ethical standards that in and of themselves are trustworthy. And when this matter came before this committee several weeks ago, there were dissenters on the other side, on the Republican side, as to whether or not this was even worthy of talking of. They accused us of smear and harassment to even raise the facts brought up by ProPublica. And I also want to say their second argument we've just addressed here, and that's separation of powers. Do we have any business as Congress when it comes to the ethics of the court? Well, I thought that we did until we received a response from Chief Justice Roberts, and let me read it to you. This response was from the 2011 year-end report on the federal judiciary. Chief Justice Roberts wrote, "In addition to establishing judicial conference, Congress has enacted legislation addressing a number of specific ethical matters. In particular, Congress has directed justices and judges to comply with both financial reporting requirements and limitations on the receipt of gifts and outside earned income." Then he says, "The court has never addressed whether Congress may impose these requirements on the Supreme Court. The justices nevertheless comply with these provisions." In other words, I think he's going to the heart of the question as to whether anyone can raise a question about the ethical standards or establish ethical standards, even those embraced by the rest of the federal government. That to me gets to the heart of why we need to enact legislation, Senator. White House has a bill on the subject, others do, and I'm sure this committee is going to address it. This is not a witch hunt. This is not a smear. This is not a harassment. This is to try to rescue the reputation of the court from some very sordid facts that have been disclosed and proven.
And as you know, because you read it, beginning on page 4 of my testimony, written testimony, I considered not just whether it was encouraged that I come, but whether I come and testify today would be inconsistent with the independence of the judiciary or separation of powers. Again, emerging from President Nixon's administration is Supreme Court jurisprudence that says sensibly that the three branches are not each in a silo. We've divided power so there'll be checks and balances. And if Congress is taking action that doesn't impact the performance of the court's core function, that's not a separation of powers violation. In fact, the DC Circuit case decided that in a case in 1994 concerning Congressman Rose. No separation of powers problem. And the core function of the courts is to decide cases impartially. Independence can be helpful to that, but independence is not an end in itself. An independent judge or an independent judiciary could be a dishonest judge or a dishonest judiciary. And therefore, a delicate balance has to be struck between the interests of independence in assuring that judges, like every public official and every citizen in the country, is somehow accountable. And the financial disclosure statute that you enacted and the Judicial Conference has a responsibility to properly implement is an important and appropriate element of that accountability.
Senator Hirono.
Thank you, Mr. Chairman. Judge Wolf, does the Supreme Court have a code of ethics that applies to it?
No.
Is there a code of ethics that applies to the federal district and circuit courts?
Yes.
Is there any reason that the Supreme Court should not have a code of ethics that applies to them as it applies to every other federal judge?
As I wrote in the article that was consistent with the Code of Conduct in 2021, I think it would be beneficial if the Supreme Court had a Code of Conduct.
No.
But if I could say, as I wrote in my testimony, because I continue to think about these things, I think that the discussion of enacting a statute that would require the Supreme Court to adopt a code of conduct is distracting from the more important issue about the enforceability, well, the way existing statutes are being enforced or implemented. Because if there was a code of conduct for the court, and it was the ultimate arbiter of whether a justice was complying with the code of conduct, you'd have, I predict, enforcement problems that are similar to the problems that I've identified with regard to the Ethics Act.
The enforcement of a code of conduct is, I think, a separate issue that we would need to address. But really, the bottom line question is, should they have a code of conduct as applicable to them as to every other federal judge? And your answer is yes. We can figure out how to do it. For example, in Hawaii, our Constitution requires the Supreme Court to establish a process where it will abide by a code of conduct, and there is established a commission that does not have any judges, and if that commission determines that there needs to be a further referral, then it does go to the Supreme Court, but the justice who is involved would have to recuse himself. So there are ways that we can do the enforcement part.
I'm sorry to interrupt you, Senator, but I'd actually like to say something to support you. We have the same thing in Massachusetts. After I worked for Attorney General Levy, I was the young junior co-counsel to the former president of the American Bar Association. In the Massachusetts Supreme Judicial Court, we prosecuted the chief judge of the state trial court for ethical violations, including alleged perjury.
So there are ways that we can determine how the enforcement will occur. So that doesn't get away from the really bottom line question. And to the public, when they see articles that say that we have a Supreme Court justice who received over $500,000 worth of airfare or whatever it is, I think common sense says that something is wrong here, that this was not disclosed, and there's some kind of a loophole that enabled this justice to think that he did not have to disclose this. And now we have a Supreme Court telling us that they do have practices and principles that applies to them. And I'm just wondering, why is it that they are so reluctant to impose a high ethical standard to itself? They are the highest court of the land. And when I listen to my friends on the other side of the aisle, it really seems like to me when they attack you, they are attacking the messenger. And really the message is, should they not have a code of ethics? I think that's such a simple thing, you know? My gosh, they does protest too much. Thank you, Mr. Chairman.
Before we wrap up, you asked for 5 minutes to respond to the various accusations and insinuations of the ranking member, and I think based on what I saw here, that is appropriate. So I will yield you 5 minutes. Probably not. We have a vote we need to get to. Proceed.
Well, I guess I would say two things, and I'd have to look more closely at my notes.
Does not hold back your opportunity to write a response as a QFR in the week that follows the hearing.
I'm not here as part of a witch hunt. I'm here because I hope to contribute to reframing some of the important issues and prompting, maybe naively, a more civil, sensible discussion of them. I do think, as I said earlier, that all of you in the Senate should and do have an interest in whether legislation your predecessors enacted after Watergate is being properly implemented. When Senator Kennedy says the committee found 4 times that there was no violation, no willful violation. First, although I have read Judge Moscoff's letter, which I got yesterday, based on that and other information available to me, I don't believe that that is correct. And again, and I mean this respectfully, Senator Lee, I don't mean to be provocative, and I'd be happy to talk to you about this afterwards if you don't get more time. It's not up to the Judicial Conference to determine whether a violation occurred. If it's to determine whether there's a reasonable cause to believe that one may have occurred, and then to refer it. It's comparable to the grand jury process and the trial process. And as I said, if the Judicial Conference has arrogated to itself authority that you didn't give it, that's not proper, and I thought would be a matter of concern to all of you. There are a number of things that Senator Kennedy pulled out of the media that are not true. But for example, he was talking about a death penalty case where there was a motion to recuse me because at a time, it's called United States versus Sampson. I looked at it this morning. At a time when a professor was not on the witness list as an expert, although he had, for an earlier case, been on the witness, an earlier iteration of this case, been on the witness list. I moderated a program about a film where he was one of the speakers. I had never met him before. As soon as I learned that he was going to be a witness at the retrial, I told the parties. And I told them they could ask me any questions. I told them what occurred. And they sent out the FBI, the Massachusetts State Police, the Internal Revenue Service to investigate the veracity of what I told them. And I gave them the film, the video of the event. And they all said, the government said, I wasn't prejudiced, but a reasonable person could question my impartiality, the standard under 18 United States Code 455A that applies to judges and justices. I considered that seriously. I wrote a 53-page decision, and I found that a reasonable person could not question my impartiality, and therefore I had a duty to continue to sit, which is what the jurisprudence is. Evidently, the Solicitor General didn't authorize an appeal. That was an appeal. I didn't recuse myself. I did transfer the case long after to one of my colleagues because of other responsibilities that I had. But I didn't recuse myself. And I didn't leak any information to the FBI. You can read a 661-page decision that I wrote, Senator Kennedy, that starts by saying everything secret degenerates, even the administration of justice. That's a decision I wrote after 9 months of hearings that exposed massive corruption in the FBI in connection with Whitey Bulger, its top echelon organized crime informant, and his sidekick, Stevie, the rifleman Flemmy. In that decision, I describe in detail the pattern of the FBI putting false, a particular FBI agent, putting false information in informant files to direct attention from real culprits. That was put in there at a time when I was a prosecutor in investigating a leak in a case that compromised a case against a state representative. That's only one of the many
Well, I'll leave
statements.
you freedom to continue to respond as you see fit to the allegations.
I'm going to stop there, but can I say one more thing, please? I see I've got 1 minute, 3 seconds, and I think this is important, and it relates to some things that come up. I've explained why I'm here today. Some people I respect advised me not to do this, even though it was permissible, appropriate, that I would be subject to various unfair attacks. It's just the toxic political environment. And I thought about that. And I'd like to tell you why I did it. I did it because so many of my colleagues on the bench are deeply disturbed themselves. I'm a senior judge, I don't get paid. I would get my salary for life if I were fully retired. But so many of us work so hard to give integrity to the ideal of impartial, equal justice under law, and now that ideal is beleaguered. I do it because my friend Dr. Jim O'Connell, the founder of Boston Healthcare for the Homeless, who's with me today, and others, tell me, what are we going to tell our children about their ability to respect the courts? I do it for my law clerks. My law clerks are here. The code of conduct and the ethical opinion says that I can't use them for anything that's substantial. I told them they didn't need to work on this. They asked to. This is their vacation. I paid to bring them here. They wanted to do it, and they've thanked me for doing it because they come into the profession the way you and I did, with ideals. And all this controversy is generating skepticism and hopefully not cynicism, because our profession needs ideals. And
That's a good tone to end on, so let me leave it there. Let me just remind everybody that the hearing is titled Review of Federal Judicial Ethics Processes at the Judicial Conference of the United States. As a result of this effort, we have received a very significant document, perhaps the most complete response from the Judicial Conference ever about its processes. We have a fact witness who was present to see these processes in action, who has testified about what he saw in that time, and I believe my opening statement and my questioning have all been very factual and calm, as I think is appropriate in these circumstances. And what we've heard is that this hearing has the tone of a witch hunt, that we're attacking a member of the Supreme Court. There has been both interrupting and shouting taking place. There has been mocking and insinuating taking place. And it just seems to me that I'd like to get this work done without all that drama. I think there are real questions that need to be answered, and I intend to continue to pursue them. And with that, the hearing is adjourned.
A Russian man claiming to hold top-level secrets about Russian advanced bombers has just turned up at the U.S. southern border, seeking asylum. The man claims to have been an engineer at a production facility over in the city of Kazan. And he says that he possesses top-secret information about the White Swan Tu-160, which is the most advanced bomber in the Russian arsenal. U.S. border officials, they interviewed the man, and they determined that his story was in fact credible, and eventually passed him off to the FBI, who are still in the process of interrogating him right now. However, analysts have pointed out that the fact that the story was even leaked to the public is an indication that perhaps the American government is encouraging other Russians who also hold top-level secrets to also escape to America. And if you thought that was interesting, well then you should click on that button below this video and check out Epic TV, one of the best no-censorship video platforms on the internet.